That FBI Director Kash Patel may be out of a job in the coming months. 3 people with knowledge of the situation say President Trump and his top aides have grown tired of Patel and the unflattering headlines he's been generating recently, including using a government jet to visit his girlfriend and enlisting a SWAT team.
FBI Director Kash Patel might be facing what sources are calling the most serious legal jeopardy any FBI director has faced in modern history, and federal judges are reportedly sending signals that they're prepared to use contempt powers against him if he doesn't stop what they characterize as lying about court orders. We're not talking about typical political disputes or bureaucratic disagreements. We're talking about reports that Patel has been telling Congress that judges ordered the Epstein files to remain secret, when those same judges are allegedly saying publicly that's not what their orders say, that Patel could release the files if he wanted to, but is choosing not to. And when federal judges catch someone misrepresenting their orders, when they see senior officials potentially using fake court restrictions as cover for refusing to comply with federal law, they have tools: contempt citations, fines, even jail time until compliance occurs. And sources suggest multiple judges might be signaling they're watching Patel closely and prepared to act if he continues down this path. Which means the FBI director could potentially face the choice between releasing files Trump wants buried or facing contempt charges that could land him in custody. But before we break down how Patel's alleged misrepresentation of court orders could lead to contempt proceedings, real quick. You cannot trust mainstream media to explain what it means when judges publicly contradict an FBI director's claims about their rulings. That's why we built John Brown Show, to bring you real stories, real context, and no corporate spin. If you want analysis that actually connects judicial pushback to potential criminal consequences for covering up the Epstein files, hit that subscribe button right now. Because what's happening with Patel and these judges could become a constitutional showdown over whether Trump officials can ignore federal law. Your subscription actually matters here. All right, let's get into what Patel has allegedly been telling Congress versus what judges are reportedly saying, because the contradiction between those two narratives might be the key to understanding why Patel could be in serious legal trouble. Sources indicate Patel has been claiming that court orders prevent him from releasing the Epstein files, that judges ruled the documents must remain sealed, that his hands are tied by judicial restrictions. But reports suggest federal judges have been saying publicly that's not accurate, that there's no blanket order preventing release, that the FBI has authority to disclose the records. And when there's that kind of gap between what a government official claims judges ordered and what judges actually ordered, that's potentially a crime. Lying to Congress is a federal offense. Misrepresenting court orders could be contempt, and violating federal law by refusing to release files that the Epstein Files Transparency Act requires could be obstruction. Patel might be facing multiple potential charges if prosecutors or judges decide his conduct crosses legal lines, and the fact that he's the FBI director makes it worse because he's supposed to enforce laws, not violate them. Let's start with what the law actually requires, because understanding the legal framework helps explain why Patel's alleged refusal to comply could constitute criminal conduct rather than just policy disagreement. Reports indicate Trump signed the Epstein Files Transparency Act in November 2025. That law allegedly required the Justice Department and FBI to release all Epstein-related files within 30 days. Not some files, not redacted versions, all files. Complete disclosure within a month. Think about what that statutory language means. Congress passed a law, Trump signed it, it became binding legal requirement. The FBI doesn't have discretion about whether to comply. They have to comply. That's what laws do. They create mandatory obligations. And when government officials refuse to follow clear statutory requirements, that's potentially criminal conduct depending on their reasons and whether they're acting in good faith. But sources suggest when the deadline arrived, the FBI didn't release most files. Reports indicate less than 1% of documents were made public. The rest remained hidden. Congress allegedly started demanding explanations. Why didn't you follow the law? Why are the files still secret? What's the justification for refusing to comply with statutory requirements? And Patel's reported answer was that court orders prevent release, that judges ruled the files must stay sealed, that he's legally prohibited from disclosing them. That sounds like potentially valid explanation. If courts order documents sealed, executive branch might have to comply with those judicial orders. Separation of powers requires respecting court rulings even when executive branch disagrees with them. Make sure you're subscribed to John Brown's show because here's where the situation allegedly gets problematic. Federal judges started saying publicly that Patel's characterization of their orders might not be accurate. Sources indicate Judge Paul Engelmeyer wrote that the government is the logical party to release Epstein files. That's not language suggesting courts blocked release. That's language indicating courts expect government to disclose records. And reports suggest other judges made similar statements, that there's no blanket restriction preventing FBI from releasing files, that limited protections might apply to specific documents but not to entire investigative record, that Patel could release substantial material if he chose to. When judges publicly contradict what a government official claims their orders say, that's a serious problem for that official's credibility and potentially their legal standing. But what might make Patel's situation particularly dangerous legally is that he allegedly made these claims directly to Congress under circumstances where lying would constitute federal crime. Because when you testify before Congress or make official statements to congressional committees, you're subject to penalties for false statements. And sources suggest Patel's testimony might have included assertions about court orders that judges are now contradicting. Reports indicate Democratic Congressman Dan Goldman confronted Patel about the court order claims. Goldman, who allegedly was a federal prosecutor for 10 years, pressed Patel on specifically which court orders prevented releasing witness interview statements. And Patel reportedly responded by questioning whether Goldman understands how court orders work. That's not how someone responds when they have good answer to legitimate question. That's how someone responds when they're caught making claims they can't substantiate. Think about what that exchange reveals. Goldman knows how court orders work. He was a prosecutor. He's read thousands of court documents. When he asks for specifics about which orders prevent release, he's testing whether Patel actually has legal justification or is making it up. And Patel's reported response, questioning Goldman's understanding rather than citing specific rulings, suggests Patel might not have had good answer because the restrictions he's claiming might not actually exist in the form he's describing. And sources indicate there was another confrontation that could be particularly damaging for Patel. Reports suggest Congressman Jamie Raskin played video of Patel from before he became FBI director. Patel allegedly appeared on a podcast where he was asked why the Epstein files haven't been released. And Patel's reported answer was simple: because of who's on that list, that the files were being hidden to protect powerful people. Now, Raskin allegedly confronted Patel with his own previous statement. You said the files were hidden to protect powerful people. Now you're FBI director and claiming court orders prevent release. Which is it? Are you protecting powerful people like you said before, or are court orders preventing release like you claim now? And sources suggest Patel didn't have coherent response that reconciled those contradictory positions. Now, that contradiction might be central to potential criminal charges. If Patel knows the files could be released but is choosing not to because of who's named in them, and he's lying to Congress by claiming court orders prevent release, that's potentially multiple crimes. False statements to Congress, obstruction of justice by hiding evidence, abuse of position by using FBI directorship to protect powerful people from exposure. Now let's focus on what federal judges are reportedly saying versus what Patel claims they're saying, because the gap between those two versions might be the basis for contempt proceedings if judges decide Patel is misrepresenting their rulings. Sources indicate judges have been making public statements and issuing opinions that contradict Patel's characterization of judicial restrictions on the Epstein files. Reports suggest Judge Engelmeyer specifically wrote that the government is the logical party to release the files. Think about that language. If a judge is saying the government should be releasing documents, that's not consistent with claim that courts ordered those documents sealed. That's the opposite. That's a judge indicating release is appropriate and expected. And sources indicate other judges have made similar statements. that the FBI has authority to disclose records, that limited protections might apply to specific materials but not blanket prohibition on entire investigative file, that statutory requirements for transparency should be honored unless specific compelling reasons exist to withhold particular documents. All of that reportedly suggests judges don't believe they've created obstacles to release in the way Patel is claiming. Think about what happens when judges publicly contradict government officials' characterization of their orders. That's judges saying you're misrepresenting what we ruled. You're claiming restrictions that don't exist. You're using our orders as excuse for conduct we didn't authorize. And when judges feel their authority is being misused that way, they have tools to respond. Contempt powers, orders compelling compliance, sanctions for misrepresenting judicial rulings. But there's allegedly another element that makes this particularly serious. Sources suggest some of the court orders Patel might be citing were narrow rulings about specific documents in specific contexts. But Patel could be taking those limited restrictions and claiming they apply broadly to everything. That's misrepresentation even if he's technically citing real court orders, because he's allegedly expanding their scope beyond what judges actually ruled. And when you misrepresent court orders to Congress, you're potentially committing multiple offenses. False statements to Congress is one crime. Contempt of court for misusing judicial orders is another. And if the misrepresentation is being used to justify violating federal statutory requirements, that could be obstruction. Each element potentially carries criminal penalties or contempt sanctions that judges can impose. But let's talk about what contempt of court actually means and why sources suggest it could be particularly dangerous for Patel. Because contempt isn't just lawyers being upset. It's a legal mechanism with serious consequences that judges can use against anyone, including senior government officials who violate court orders or misrepresent judicial rulings. Reports indicate federal judges have inherent authority to hold people in contempt. That power exists to protect judicial authority and ensure court orders are respected. And contempt can take two forms: civil contempt, which is designed to compel compliance, and criminal contempt, which is designed to punish violations. Both can involve fines, both can potentially involve jail time. Think about how that applies to Patel's situation. If judges conclude that Patel is misrepresenting their orders to justify refusing to release files that federal law requires, they could cite him for contempt. They could order him to release the files. They could fine him if he refuses. And if he continues defying orders, they could potentially order him jailed until he complies. That's not theoretical. That's actual judicial power that gets used when senior officials defy courts. And sources suggest there's precedent for judges holding high-ranking officials in contempt. Governors have been held in contempt for refusing to comply with desegregation orders. Sheriffs have been jailed for contempt when they violated court rulings. Even executive branch officials have faced contempt sanctions when they defied judicial orders. The principle is that nobody is above the law, and judicial authority must be respected regardless of how powerful or well-connected you are. But there's reportedly another element specific to Patel's situation. If he's not just violating court orders but actively misrepresenting what they say, that could be viewed as particularly egregious by judges. Because that's using judicial authority as false cover for conduct courts didn't authorize. That's claiming judges said something they didn't say to justify violations of federal law. Judges might take that especially seriously because it undermines judicial credibility and authority. Share this with everyone because the contempt process could move quickly once judges decide to act. Sources suggest a judge could issue order directing Patel to release files or explain under oath why specific court orders prevent release. If Patel can't cite valid restrictions, judge could find him in contempt, fine him, order him jailed. All of that could potentially happen without lengthy trials or complex proceedings. Contempt is summary power. Judges have to enforce their authority immediately, but contempt might not be the only legal jeopardy Patel faces. Sources suggest there could be additional criminal exposure if prosecutors decide his conduct violated federal statutes. And when you're FBI director, the irony of potentially facing federal prosecution for violating laws you're supposed to enforce makes the situation even more problematic. Reports indicate lying to Congress is federal crime under 18 U.S.C. 1001. If Patel made false statements to congressional committees about why files aren't being released, if he claimed court restrictions that don't actually exist, that could constitute violation of that statute. Prosecutors would need to prove he knowingly made false statements. But if judges are publicly contradicting what he told Congress, that provides evidence his statements might not have been accurate. And sources suggest there's potential obstruction of justice exposure. If Patel is refusing to release files specifically to protect people named in them, if he's using his FBI directorship to hide evidence of crimes or misconduct by powerful individuals, that could be obstruction. The fact that he allegedly admitted before becoming director that files were hidden to protect people on the list could be used as evidence of his intent now that he's the one doing the hiding. Think about how prosecutors might build that case. Patel's own previous statements establish he knows why files are being hidden, to protect powerful people. Now he's FBI director and continuing that same hiding while claiming different justification. That pattern suggests consciousness of wrongdoing, that he knows he's protecting people but is lying about his reasons for doing it. That's the kind of evidence that supports obstruction charges. But there's reportedly another potential charge: abuse of public position. If Patel is using his authority as FBI director to shield people from exposure for reasons unrelated to legitimate law enforcement purposes, that could be federal crime. Officials can't use their positions for corrupt purposes. If the purpose is protecting Trump or other powerful people from embarrassment, rather than legitimate investigative concerns, that crosses line into criminal abuse of authority. Now, many sources suggest prosecutors haven't acted yet on any of these potential charges, but the fact that judges are publicly pushing back, that Congress is documenting Patel's statements, that his own previous admissions are on video, all of that creates potential evidentiary record that could support prosecution if Justice Department decides to pursue it. Though given Patel is FBI director and Trump's loyalist, prosecution would likely only come from future administration with different priorities. But beyond the legal jeopardy, sources suggest Patel's situation has enormous political implications for Trump and for Republican control of information about Epstein's network. Because the fight over these files isn't just about Patel's legal exposure, it's about what those files might reveal and who they might implicate if they ever become public. Reports indicate Trump signed the transparency law, but that might have been political calculation rather than genuine commitment to disclosure. Trump could have assumed his FBI director would find ways to avoid actually releasing sensitive material, and Patel's appointment might have been specifically because Trump knew he'd be loyal enough to protect whatever names appear in those files, regardless of legal requirements. Think about what that means if accurate. Trump creates appearance of transparency by signing law, but ensures his FBI director will block actual transparency by refusing to release files. That gives Trump political cover while maintaining actual secrecy. He can claim he signed the law, and it's not his fault if bureaucratic or legal obstacles prevent disclosure. Except the obstacles aren't real. They're manufactured by his own appointee. And sources suggest the files likely contain information about Trump himself, his documented associations with Epstein, his appearances at properties and events, his connections to people in the network. If those files became public, they could be politically devastating, which creates obvious motive for Trump to ensure his FBI director prevents their release regardless of what the law requires. But there's reportedly another political element. Congressional Republicans might be complicit in the cover-up by not demanding more aggressive action against Patel's refusal to comply. If they genuinely wanted transparency, they could use appropriations power or other congressional authorities to force release. The fact that they're not doing that suggests they might also want the files buried because of who they could implicate. Share this video with everyone you know, because the political dynamics could shift if Democrats take the House in 2026. Sources suggest they might use investigative power to document the cover-up, subpoena Patel and other officials, force testimony under oath about why files remain hidden, build record that could support impeachment articles against Trump or others for obstruction. The files themselves matter, but so does the cover-up of the files. Both could become grounds for accountability if Democrats gain power to pursue it. So what actually happens next with Patel and the Epstein files? Because sources suggest several possible scenarios depending on how judges and Congress respond to his continued refusal to comply with federal law. None of them might be good for Patel if he maintains current course. Reports indicate judges could issue orders compelling specific release, not just general statements that files should be disclosed, but actual court orders directing FBI to release particular categories of documents by specific deadlines. If Patel refuses to comply with direct court order, contempt becomes almost certain. Judges don't tolerate defiance of their explicit directives, and sources suggest Congress could increase pressure through multiple mechanisms, holding Patel in contempt of Congress for refusing to comply with lawful requests, cutting FBI funding until transparency requirements are met, subpoenaing the files directly rather than waiting for executive branch to voluntarily release them. Each approach creates additional pressure that might force release or at minimum creates political costs for continued obstruction. But there's reportedly another possibility, that Trump decides Patel has become too much of a liability. Sources indicate Trump's administration might already be considering replacing Patel because of various controversies, including use of government jets and other issues beyond just the Epstein files. If Trump removes Patel, new FBI director might take different approach to transparency. Though equally possible, Trump installs someone even more loyal who continues the cover-up. Think about Patel's calculation. If he releases the files, he probably loses his position because Trump expects loyalty and protection. If he continues refusing, he faces contempt charges and potential criminal prosecution. He's trapped between legal jeopardy and political loyalty. And that kind of impossible position often leads to people making mistakes or taking actions that make situations worse rather than better. Sources suggest the most likely scenario is continued standoff. Patel keeps claiming court restrictions prevent release. Judges keep saying that's not accurate. Congress keeps demanding files. And nothing actually happens because nobody with power to force the issue wants to escalate to the point of actually arresting FBI director or imposing severe sanctions. The system is paralyzed by the fact that holding Trump officials accountable requires will that might not exist yet among those with authority to act. So here's what Patel's situation reveals. An FBI director allegedly lying to Congress about why the Epstein files remain hidden, claims that court orders prevent release contradicted by the judges who supposedly issued those orders. Potential criminal exposure for false statements, obstruction, and abuse of position. Contempt jeopardy if judges decide to enforce their authority against someone misrepresenting their rulings. And political calculation where protecting Trump and powerful people in the files takes priority over following federal law. The legal implications could be enormous if judges or prosecutors act. Contempt citations that could include fines or jail time. Criminal charges for lying to Congress or obstructing justice. Precedent that even FBI directors can't misrepresent court orders to avoid statutory requirements. All of that depends on whether judges and prosecutors have will to hold powerful Trump officials accountable rather than just issuing stern warnings that get ignored. And the political stakes are just as high. The Epstein files likely contain information about Trump's associations and activities that could be devastating if exposed. The cover-up itself might constitute impeachable conduct if Democrats gain power to investigate it. And Patel's role as Trump's shield against transparency could make him both legally vulnerable and politically expendable, depending on how much heat the situation generates. The question is whether judges actually follow through on their implicit threats to use contempt power, whether prosecutors eventually pursue charges for conduct that appears to violate multiple federal statutes, whether Congress forces the issue through appropriations or investigations rather than accepting Patel's excuses. Until someone with authority decides to escalate beyond warnings to actual enforcement, Patel might continue claiming fake court restrictions while the files remain buried and the people named in them remain protected from public exposure. Stay tuned.